Awesome. Well, thank you so much. And Miss Lauren Morgan, please feel free to start.
Hi, you guys. Good morning. I hope everyone is doing well. Thank you guys for being here and joining. We have a small, intimate group on live, but that's awesome because you guys get to ask me direct questions and have access to me, and we can really kind of curate this to fit your current business needs and whatever questions you guys have. So I am not a typical presenter where I talk at you or I go through the slides and read everything. I love to have conversations. So I know some of you guys might be multitasking or just getting into work. Not a problem. I'm not going to put anybody on the spot. Don't worry. But the option is there for you guys to engage with me and interact throughout. I do have a presentation. I'll leave some time for questions at the end. But if you need me to give more clarity on something or to ask more questions throughout, you can either raise your hand, you can speak, or you can put some information into the chat. And I'll check in kind of every other slide or things like that. And so we're doing the overall basics of legal today and how it impacts your business. And if you have any questions around this, I have a lot of experience in this. I started my first business at 16. So not only am I a business attorney, I am an entrepreneur as well. So I have a unique perspective to lend to this. I am the founder of my own firm as well. So I am an entrepreneur currently still, and I know this kind of in and out and navigating. So without further ado, let's kind of hop in here and I'll share my screen. Just so you guys know, I am the owner of the Legal Know as well. That's what my slides are going to reference and say, but the Legal Know is a legal community that I have and offer, but it's the same information. It mirrors the activated law business from that angle. So this is the introduction of it. And it's just getting your legal stuff together, right? From the entity all the way down to copyright and your intellectual property and making sure we have everything kind of covered here. Today, during our time together, we are going to cover where should we basically kind of get started with everything, what types of entities there are, how to leverage our entities even. I'm sure a lot of you guys in working with the Arizona Minority Development Center are already business owners. You've probably already accomplished this, but at different stages of your business, we should actually leverage different types of business to our advantages, maybe having multiple. We're going to talk about that a little bit. We're going to talk about some common contracts every business owner should have, some common contract clauses to ensure you are protected, as well as trademarks and copyrights, and what you can do next to kind of ask me questions, get in touch with me, and to follow up with everything. So let's hop into entities. There are many types of entities, as I'm sure you guys are aware of, but how do we kind of leverage all of this? So sole proprietorship is when you have not set up your business with the state yet, you haven't registered. And next is going to be a partnership. Partnership is not recognized in all states. It's actually not recognized in the state of Arizona. So when you go to set up, they're going to ask you if you want to be an LLC or a corporation. Partnerships can essentially, if you want to be a partnership, you're just going to go into the LLC realm usually, and you can still have a partnership agreement that kind of mandates and just kind of lays out the land between the partners. But in Arizona, they don't have a partnership agreement or partnership entity type. It is an LLC only. Otherwise, you're going to be a corporation. And corporations can either be a S Corp through an election form. In Arizona, we don't have an S Corp entity type as well. Then also, but in tax time, you can elect to be taxed as a S Corp. We have a nonprofit, and we also have a benefit corporation. So by show of hands, this is going to be one of those engagement areas. How many of you guys know what a benefit corporation is? Nobody. Okay, so I'll take some time just to kind of talk about what a benefit corporation is. So before I talk about it, I want to see how many of you guys actually have seen them and didn't know what it was. How many of you guys have gone to a business and on the door or on their information pamphlets have seen a B with a circle around it? We've seen that. So a B with a circle around it is indicative of a benefit corporation. Benefit corporations are like any other corporation, except they have a certificate where they have vowed to have a higher standard and principle in operating their corporation. They are more transparent with their financial records. They have a higher standard and public responsibility that they intentionally take on. No one forces them for this, but they personally, as a business, have said, we want to hold ourselves to a higher standard publicly because we want people to trust us and do business with us, because corporations sometimes can get a bad rep and not be trustworthy of doing good business with them. So that is what a benefit corporation is. They operate the exact same way as a corporation. They just have higher standards. And because of that, they have more of a transparent record with their financials, with their practices, their mission statement, things of that nature, and they hold themselves publicly accountable. So the public footprint and impact that these companies are taking, they are very socially aware of the things they are doing to affect the public. So benefit corporations are really cool. And that's why I want to make sure you guys know about them and how to interact with them, because they can be great to do business with. And because of that, pretty much from that last slide, we can summarize all businesses as one or two types, right? LLC, for the sake of this, like I mentioned, partnerships aren't recognized in the state of Arizona, but for the other states where they are recognizable at, it's essentially going to follow the LLC structure. So LLC stands for Limited Liability Corporation, and corporation stands for corporation, but you can also see that as Inc., Corp, S Corp sometimes. LLCs have members, and corporations have stakeholders and stockholders. LLCs can be member managed or manager managed. That manager can be one of the members, or it can be someone appointed outside of the LLC to come in and manage. For corporations, the stockholders and the shareholders are who make the decisions on the day-to-day operations. Also, corporations have boards. So this is going to be who is running the corporation day-to-day. Owners have a percentage of the LLC company, and based off the amount of shares or stock you have in a company, you have a percentage in the corporation. The operating documents that you need to have in place that govern the relationship of the entity as well as the owners is going to be an operating agreement for the LLC and bylaws for a corporation. Any questions? You guys, like I said, can feel free to pop them into the chat or into raise your hands here, but as promised, I want a couple slides and then I will pause to ask any questions. Okay, not seeing any, we'll keep going. We're gonna hop into contracts now. So the first couple of slides talk about entities. Once we have that in place, the next thing we're gonna do is contracts. The operating agreement and the bylaws are actually contracts between the owners of the company and the new entity that is set up. Once you set up an entity with the state, it becomes its own person, which is why you set up an EIN number for it, the social security number, you should have separate bank accounts, etc. That is what's going to lend it over to being its own person, if you will, its own entity that we're working with. So a contract is a verbal or written agreement. I always put in verbal because it's technically accurate. However, I emphasize strongly that verbal agreements are not enough, honestly. We want to make sure that we have things in writing so that we can accurately detail out where the problem came about, right? So verbal are technically, it is a thing. We can have verbal agreements, but they are very, very, very hard to enforce because it becomes a he say, she say. And it's not that even that people aren't integrous. What happens is that people recall things differently. There was a breakdown in communication that we weren't aware of until a certain point of the contract. And when you have things written out, written out specifically, we can usually pinpoint where that issue has come up at quicker than when it's verbal, right? So written agreements are always the best way to go. I do want to pause really quickly because I did get a question about the S Corp and C Corps. So I want to acknowledge that before we get too deep into contracts here. So the question is, how can you go from an LLC to an S Corp? So as I mentioned, S Corps aren't recognized in the state of Arizona. This is an election that you actually do at tax time. So you would have a conversation with your accountant. It's a form 2553 that they file at the time of doing your taxes, that even though you are an LLC, you are electing to be taxed as an S Corp. Other states that do acknowledge that it is an S Corp, you would fill out the amendment forms, articles of amendment, showing that you want to change your business over from a LLC to an S Corp. Some states process have it where you actually have to redo your articles of organization as well as that. So it's multiple steps in the process of actually converting from an LLC over to an S Corp. But in the state of Arizona, we don't have that in place. We actually have it where you fill out an S Corp form at tax time and are taxed as an S Corp. Yes, you can come up and ask your question.
Hi, Lauren. Thank you so much for hosting this event. I just have a quick question for you. So as far as the contract, because with the LLC, you have an operating agreement. If you're going from LLC to S Corp, is it just best to kind of get a lawyer in there to redo the contracts and then just annul the full operating agreement and then do a different contract for the S Corp?
Yes, so great question with that. So the S Corp is actually going to be under the corporation category, and you won't even use the operating agreement anymore. You need bylaws. And bylaws are a little bit more tricky to navigate. You have to have like the board in place. It's going to talk about how you're going to issue out your stock, how do the meetings run, your meeting notes on the different requirements that corporations have versus an LLC. And just to make sure you're abreast of it, even if you do your own form, I would recommend a minimum of a consult with an attorney, just because there's a drastic difference in how you are operating as an LLC and the requirements there, along with the requirements for a corporation. So hopefully that answered your question. Did you have any more follow-up with that?
I actually do. This is super interesting. So if you have an LLC with, let's say you have two members of that LLC, does it automatically go 50-50 if you go from LLC to S Corp as far as stocks, because now you're working with stocks? Or is that you just kind of do the stock distribution based upon the new S Corp agreement?
It's going to be based off of you guys' agreement. So you are actually going to elect that. When you go in and you're converting from the LLC to the S Corp, you get to put in per owner who's going to own what. So that will be a discussion that you guys would have between the two members. And when you go in and set up that paperwork and that documentation, you will then input what you guys have agreed upon and decided. And then that will also be reflective in the bylaw agreements, the new corporation documents that we're going to put in place. And the reason that's important, or the thing to navigate with that, is usually with corporations, even if it's two people starting off, over time, more people come in and take stock. So you want to talk about how that's going to move. And also, this is getting really depth, but you can actually have different types of stock within a corporation as well, right? So you can have stock type A, you can have type B, type C, type D. And a great company to look at for an example of this is Alphabet, the company that owns Google. They have different types in the ownership type. So just the founders and a couple of the angel investors have type A stock in Alphabet. And then they go down the totem pole from there. Certain employees have type B, depending on how long they've been with them, but other employees have type C, and then publicly there's type D, and so on and so forth, right? So it can get very complex. So you guys can start off and issue type A, and then as you expand and grow and bring in more people, you don't necessarily have to give up your stock. You can create a new type of stock and issue stock from there. And this happens through all types of events, such as the stock splits that we see on the stock exchange all the time. These are real life occurrences of what causes these things to happen. We want to create more stock so we can bring in more people, or, create more. So great questions. These are amazing. Are you currently going through, are you considering doing this? Awesome.
Yeah, I actually have some more, so I think I might contact you after, but I'm super excited to know if you're considering just having an IPO business, is it just best to kind of already allocate those stocks in like stock A, stock B, stock C? And then if it is, do you just does all of it all come from just one pool, and you just set aside like a specific amount from that 100%?
Great question. So when you do the stock split, it actually is creating more. I don't recommend necessarily pre-allocating it up front, because every time a company goes through when they're issuing more stock or they're creating another stock, you have to get like I said, the permission of the board, things like that. There's usually a restructure that is happening even from a stock level for them to create a new stock. So there's a lot of meetings that actually happen and discussions on how you want to do it, how the ownership and things like that are going to happen when they are going forth and issuing the stock. So lovely questions. Thank you so much for coming off camera and asking me. And like I said, I'll provide my information at the end for those who want to follow up with me directly, and maybe schedule a consult or things like that as well. Oh, Vanessa already put it into the chat. Thank you so much. Or no, she didn't. That wasn't Vanessa. That was Alika. Thank you, Alika. I didn't see her face on here, so I didn't know she was on. Thank you so much, Alika. I appreciate that. Perfect. I love it. Yes, yes. Awesome. Okay. So we'll hop back into contracts. And if you have more questions, like I said, it's not a long presentation because I like to build in these questions throughout. So we'll make it through, and then I'll still leave time at the end to come back for more questions if they come for you as well. Okay. So we want to make sure we have a written agreement that's going to be between 2 or more parties. And the intent is to bind the parties to, once again, the clear set of expectations that they've discussed and come into agreement with. You can negotiate whatever you want. It doesn't really matter what the contract is about. The most important things is that the 2 parties have a meeting of the minds and are clear on what each of them are agreeing upon at the basic level of what a contract is. So now let's talk about some different types of contracts that I believe every business starting off should have. These 5 contracts. I believe it's 6 actually. Let's go to the slide and we'll see for sure. It's 6. 6 contracts every business, product-based or service-based, should have in place, because every business is going to need this to operate, right? So website terms and privacy policy. If you have a website in this day and age, most of us do, you need to be in compliance with international law, state law, federal law, municipal law, local law, county law even. It can get really specific. And I want to bring out an everyday example where we see this as well is if you go to a website and you're reading their policy of agreements, if you scroll to the bottom of the website, sometimes they'll say, if you are a California resident, click here and read these, because different policies can apply depending on where the person is living. And because we have a website, we aren't always in control of where our presence is going to reach, even with an international presence. So we have to make sure that we are complying with the GDPR bill, right? Which is from the European Union. And it really just specifies what data and information you can collect from their residents, how it's going to be stipulated, what you can control or say around or about that. And you want to make sure that you are being compliant with all of these laws. So everyone's going to need a website terms and privacy policy. If you have a website, landing pages are included in this. You want to make sure the data you're collecting on the landing page, you have to disclose that. Independent contractor agreements are going to be very important as we grow and scale as businesses. It's kind of cumbersome, not always, depending on your business type, but most of us are going to hire independent contractors prior to hiring employees. Independent contractors are someone that has their own business. They specialize in a scope of work, and you onboard them for either a specific project or you onboard them for a specific task. And as you are growing and scaling your business and understanding how things operate, independent contractors are responsible for their own taxes. You don't have to pay workers' compensation for them. And you don't also have to pay certain taxes associated with an employee with an IC. So it's usually best when people are scaling their business. And so I always say product or service-based, doesn't matter. You're probably going to need an IC starting out for your business as you grow and scale. This can be a virtual assistant. This can be literally, I know a lot of website developers, they'll hire in a web developer just for a specific project. This can be a brander for your website. I've worked with clients who are therapists, physical therapists, so they'll bring in a masseuse that has a special niche. So anything that supports your business in any capacity that you don't have a full-time position for, you can actually source out as an IC. Service agreements, this can be a product agreement if you are doing white labeling, but it basically details out the scope of work that you are providing to the individual for the price they're going to be paying. It details out how all of that is going to work. If you are products only, such as you're selling apparel, if you are selling candles, if you are selling, let's see, what else do people sell? Just anything product-based, right? If you are selling nails, some people design nails and sell those out these days. You are going to have a very specific and custom website terms and privacy policy. You don't necessarily need to have a service agreement unless you are white labeling. A website terms and privacy policy is going to be enough to cover you in the scope of work here, right? So confidentiality and non-disclosure agreements, also NDAs, are very important when you are hiring independent contractors, when you have partnerships, when anything that is around an idea that you have within your business. confidentiality and non-disclosures are going to be essential to protecting your processes, systems, and ideas within your business. Operating agreements, we just discussed this in bylaws. Those are agreements and contracts, legally binding contracts as well. So just keep that in mind when you're creating your business and starting them out. But lastly, non-competes. Non-competes are going to be really important for protecting your business and scope of work. I always talk about this illusion that when you are an entrepreneur versus employee, as an employee, we come in every day and there's work prepared for us. We come in and we're just providing the service or packaging the products, but we get these ideas that maybe we can do this easier and better than the person we're working for, but we don't really know what's all going in and taking place behind the scenes of negotiating contracts, the costs of setup, the processes, the systems. And so what can happen is that people will leave your business and say, I can do this easier and better than they can because of their limited perspective of things. And they go out and set up shop across the street from you and they try to compete. A non-compete prevents this, and it's also good with partnerships. You can use it similarly to how you would use a confidentiality agreement. They're separate agreements. However, who you want to use it with, if you have a business partner or someone you're talking about ideas with, but you don't want them to steal the idea and go and set up shop before you, a non-compete can limit this from a time frame for up to, it's not a limit of time actually, but most commonly you'll see 1 to 2 years, or it can limit it to a space radius. So within a 5-mile radius of where I have set up shop, or within the state of Arizona, if it's an online presence, et cetera. So non-competes are very helpful in this capacity. Non-competes can also be unenforceable. If it is a specialty field, for instance, my field, in the legal field, I have a license to practice. It will be, if I worked for another company and they terminated me, it will be unenforceable for them to say, you can no longer work in the state of Arizona when I have a license to practice in the state of Arizona. It would be a cumbrance to my ability to make income and to live, and that would not be found. That would be unenforceable. A court would eliminate that and say you need to have a less restrictive non-compete. But most areas, they aren't that limiting. And so you have a little bit more of a free range in when you can do it. They do have to be reasonable though. You can't say you can never do this ever again in life in any other state. That's a little extreme. So the court will kind of modify, if necessary, the limits that we put in place for that. So let's see if we have any questions around the types of contracts. Yeah, for sure. Great question here as well. Great questions. I see. I saw one else. So can you clarify the employment relationship with 1099 employees and government contracting language that indicates no more than 50% of a contract can be performed by subcontractors? Absolutely. So when you are, 1099 employees work for your company and you've contracted them out, right? When you are applying for government contracts, and it depends on the contract, sometimes it can be 25% on the contract can't be performed by subcontractors. Sometimes it's 15%. It really does depend on the type of government contract you've applied for. But essentially, if you have in your everyday scope of business and work, you are working with contractors, those independent contractors are seen as they represent your company and your brand, right? When your clients come in, they know that there's no distinction between them being a part of your company and your branding and in who you are. In government contracting, however, there are some things that your business is not even in, it's outside of the scope of work that you provide. For instance, if I did a contract, government contracting for consulting, and they said we have to do some business consulting, we have to do some financial consulting, et cetera, I don't have any independent contractors in my law firm that are providing financial services. It probably would be a conflict of work if we were not probably, it would be if we were doing your taxes as well as doing your legal entity setup and all those things and taking you through base to base on that. So if I was doing a government contracting and that the scope of work for providing to fulfill the contract was going to be around financial literacy, business literacy, things like that. I bring the financial or the business literacy and all of the people who make up my basis of employees, right? My subcontractors, but they represent my company prior to this contract. That's how we're set up. On that, I would say I am actually subcontracting and bringing in a financial company, and they are going to represent this as well. However, just because you want to disclose everything with the government, you don't want anything to be a surprise or a secret, I would still disclose that these people work for my company in a contractor position, but they represent and work for my company in a normal scope of work, even outside of this contract. But these are the companies I am subcontracting. And this is how I came up with my number, that the people who are working for my company and provide the same scope of work that I'm doing, et cetera. This is how I came up with the number of the 50%. And it does not include these people because day to day outside of this contract, I am not subcontracting with them. And this is a great example of this is when you think of primes in contracting. Amazon has independent contractors. Google, all of them have independent contractors that are working with them on a day-to-day basis. When they're going up for contracts and they're using subcontractor projects with them, that is more so the focus. And Cassandra can probably lend some more explanation on this. She's the CovCon expert on that, but that would be my understanding of it. I would still disclose it, but show them the calculations of how that is not technically a subcontractor because they're independent contractor for your company. Cassandra, did you want to clarify on that?
Yeah, you're absolutely correct, Lauren. You're going to disclose in your proposal, in your proprietary proposal, that these are 1099 employees that are considered employees, if you will, for you. But how you define that is that, they are taxed on their own by themselves, but they are committed to your company. A lot of times what I would do is show a letter of commitment, because especially if I'm putting them in a key personnel slot, the government's going to want to know that they're going to be there for the entire time, that they are committed to this job and this contract for whatever the specified time frame is. And, just really explain what it is that you're doing and how you do that. The government understands that some people choose to do a 1099 because it is more cost effective, lowers the overheads and, things like that, which makes it more attractive overall to the government and therefore the taxpayer. And that's why it's a benefit. So again, just make sure that you're clarifying and that you're documenting.
But great question. Also, could you go over if you should use I'm 1099s for ICs? That's exactly what 1099s are. They're independent contractors for your company. So 1099 is the form that they fill out, which is why they kind of get called 1099s, but technically they are independent contractors for your business, but they can be used interchangeably. So I love these questions, guys. They're so good. Keep them coming in. And sorry, I missed the question before. I'm going to go back to that one. Do you have to amend the articles of incorporation if you convert to a C Corp to S Corp? So not necessarily. I would recommend, it depends on your state. Like I said, every state doesn't recognize an S Corp. So if you are a C Corp, you are technically already an S Corp. Also, C Corp, I'm not an accountant, so double check with your accounting with this. But to my knowledge, C Corps can be elected to be taxed as an S Corp during the tax election period. So that would be something that you necessarily wouldn't need to convert with. You would just fill out that form at tax time. And especially that's more of an accounting question than it is a legal question for that form. And I am not 100% sure of the laws specifically in California. I have set up entities there. I'm just not 100% sure on the S Corp in California. So I can't answer. But yes, you are more than welcome. Awesome. All right. Did you have another question for us, Melanie?
I do. Oh, sorry. Were you talking to me?
Yeah, I was asking you. I saw your hand up and then you took it down.
No worries. Just one more question. I'm just trying to make sure I understand. So the independent contractor agreement is going to be the agreement based upon the terms that you hire that contractor for your own company. Okay. Yes. And then in that agreement, would you also include the non-disclosure, or are those two separate contracts?
Yes. So my IC contracts that I have drafted for people, and I have templates available as well, they have a non-disclosure agreement in there, as well as a non-compete clause. So my next slide, I'm actually going to talk about some common clauses I recommend every contract should have. But I would say a non-compete and non-disclosures are the actual agreements are more so used in the capacity of when you don't have a working relationship established with people, but conversations around your business are being had. For instance, I have an idea and I'm thinking about partnering with you around something, I'm going to have you sign a non-compete and I'm going to have you sign a non-disclosure agreement. In totality, we don't have a business relationship yet, but I still want to protect my ideas around if we do. And I want to protect you going into competition with me because you could potentially do that, right? So I'm going to have you sign an NDA prior to this meeting, as well as a non-compete with this agreement. I'll give this example. And you just never know what is going to happen, right? And so the common analogy I give my business owners is we want to have Beyonce energy when we walk into rooms. And as a businesswoman, not even talking about her music or her artist, honestly, I might get stoned. I'm not the biggest fan musically, but as an entrepreneur, I love how she moves as she's a businesswoman. And I know first-handedly, we have the same hairdresser out of LA who does curly hair. And he did her hair for the Super Bowl when she performed a few years ago. And everyone in that shop, which it could only be him and his assistant, the whole shop had to be closed, had to sign an NDA. If she spoke or if she didn't speak prior to her arriving, just to do her hair. This is not a business meeting. This is not an agreement here. This is nothing to do anything, but you cannot disclose any conversations, any tips, anything you learn or do about her in this arena, and the assistant as well, just because I don't know that my presence might not inspire you, right? Like just being in my presence, we don't know what this meeting is going to come through, but, and I was also informed that it does not matter what room she is in. If you if you have access to have a conversation or overhear a conversation with her on any capacity, everyone has to sign an NDA. And I want business owners to think that way, know that your ideas in your business are valuable. And you don't know what conversations are going to spark or be in rooms. And obviously we're not going to do this for like networking events or things like that. We want to be mindful of what we're saying about our business. But if we're having an intentional business meeting with someone who is positioned to maybe share this idea or to do, to go on and, replicate the idea, I want to protect myself and my business. And a very common example that this happens in, and I've actually been I'm a mentor for a organization and they host incubators. Well, it's a lot of entrepreneurs and incubators, and a lot of them are trying to figure out and like navigate, pinpoint what they want to do, but they do think tanks. It's a free for all in there. And so I tell business owners, if you're going to do one, be very careful and selective about what you're saying in there, because someone can take your idea. But more so the business that I am a mentor for, I just to encourage people, because you want to encourage that creative energy and atmosphere. I encourage them to put a non-disclosure agreement in place so other people can steal other people's ideas. So that would be a more realistic exercise on how day to day we want to do this. But if you're taking any one-off meetings with people to talk about business ideas, things like that, I would definitely make sure we're doing the non-disclosure agreements as well as the non-compete agreements.
Can I ask one more question, Lauren? And I'm not sure if this probably will have to get answered off the meeting, but some of the independent contractors that I've worked with, they've had their own just contracts. If we were to develop our own contract, like for my business, and let's just say there's something like, for instance, if we want to kind of annul the contract of the contractor within 10 days, but in their contract, it's like you have to do a 30-day notice. Which one takes effect if they're two different just like factors versus like ours and theirs?
Yeah, that's a great question. I would only have one agreement, but whichever agreement you guys do with, you should negotiate that agreement, right? Especially with smaller businesses. Big businesses are not going to do that with you. And that's okay, because what their agreements are, it's really cumbersome for them to have to negotiate with everyone on a smaller scale. So they are inherently taking the risk that they're going to be some one-off instances. And that's just a part of the cost of doing business for them. Smaller businesses, however, to take away that negotiation power and say, we're not going to negotiate this. Most of them, I haven't seen it where most small businesses aren't willing to do that. You just have to know you have that power and authority to negotiate with them and to ask for that. If you want a 10-day get out, termination period, request it. And if they're not agreeable with it, maybe you guys can compromise, come up with a 15-day or 20-day. There might be some things that they counter with, such as if you get out in 10 days, great. We're gonna apply a termination fee though, or a percentage. Those are negotiating terms that you can use, but you should only have one agreement that is governing this. It kind of defeats the purpose if you have multiple. And there's even, I'm going to have it in the next slide, a clause that you should have in agreements that speaks to this being the entire and only agreement, because you want to show this one document is going to trump any other document. So having a lot of agreements in place kind of prevents the point of us showing we've gotten really clear on what our one point is going to be. And so if you have one for your business and you prefer to use that, you can always say, hey, I prefer we use mine, but still be open and communicating with them if they want to ask additional questions that way. Awesome. So we have some great other questions coming in. For the sake of me getting through the slides, I only have about 4 slides left. So I'm going to go through the rest of the slides and then I'll come back and make sure we answer all the rest of the questions coming in. But I love you guys' engagement. I'm not shutting you guys down. I encourage you to keep it coming. And I promise we'll circle back. I'll push through. So next are the slide or the clauses I would recommend you guys to have. And these are really, really important clauses, guys. This is not inclusive to your agreement, but really quickly, an arbitration clause keeps you out of court. It keeps things confidential and it is cheaper. All small businesses need to have an arbitration clause. Even bigger businesses now are starting to put them into their agreements because it's cumbersome, it's expensive, and it's just a long time to go through having actual court dates in place. It's just too much for people. An entire agreement clause is the clause I was just telling you about. We want to show that this is the entire document. So when we were negotiating before, those emails, those conversations, they don't matter anymore. This agreement is the only thing that matters, and it's going to trump everything else that we've discussed because this is what we are saying is our final agreement, right? Let me minimize this really quickly. Our payment terms clause. This is really important as well because it dictates out how we are being paid, if there's going to be any late fees, if we are going to charge interest. Our payment terms can cost us money if we don't think through these things up front. Business happens, people are late. I recommend that people allow a grace period, but if it's something that's extremely cumbersome, where people are constantly making payments 10, 15 days late, it needs to be a part of your business model up front that you give them a grace period, but after that, there is a penalty and you disclose that you will stop delivering businesses and services after that point is reached, right? A wrap-up clause also helps with this, right? So if I've delivered the final piece of work, you will have 30 days or whatever amount of days to get back to me with any commentary or any changes, but out of this 30 days of the final draft being delivered, final letter, whatever the process is or the service, 30 days will naturally be the end of this contract if we don't have outside of a formal ending, right? This is really clear because people will come back to you in a year and say, hey, I have a question about the work you did for me a year ago. Or can you make a change to something you did for me 6 months ago? Your business has moved on and you have other clientele, your workload has changed. And if they aren't compensating you for that time, they will say, well, we still have this agreement. No, a wrap-up clause will immediately nip that in the bud. Changes are going to happen, modifications are going to happen. We want to allow for them, but we want to limit them. You don't get to come back and forth and change your mind 3 or 4 times, and I have to keep changing my natural progression of work. It's cumbersome. It's a cost of business that you are now I'm having to incur for this, and we want to limit that. So maybe we allow for 1 or 2 changes, and then in future, we don't allow any changes, or we allow them with charges associated, right? An IP clause basically it goes over who is in ownership of the intellectual property within businesses. This is especially important for consulting businesses and services where business plans are come up with, where logos are created, branding is done, photography, those in the service industry, or even in white labeling for products such as candles, etc. Who owns what we have come together to create? That is going to be very important to get clear on. Maybe it's a split ownership. What is that percentage going to be? How are the royalties going to work? What we are coming together to create in this project is essentially the whole purpose of the contract. If we aren't clear on who owns what at the end, that's going to be a problem. So people have to be very forward thinking with the end in mind when creating contracts, because there are so many different moving pieces and components. Rescheduling and cancellation clauses. This is your time. You want to make sure you have something that covers that and protects it. I'm going to hop over the confidentiality clause. We just talked about the agreements for it. So we've gone in depth about that, but I want to highlight really quickly, 10 seconds on this, the force majeure clause. This is critical, guys, because life is going to happen. Life will life, even when we are trying to have a schedule and a program, life is going to life. So we want to be prepared for that. A force majeure says when I am not in control of something happening and you are not in control of something happening, an act of God in any unforeseeable, unplannable event that neither one of us saw happening, and it has caused a breach of contract, right? There's an actual breach where I cannot deliver, you cannot pay, whatever the situation may be. There's a power outage, all the internet is down, and you cannot electronically send me payment, but this is your last and final day, etc. That's nothing we could have controlled or foresaw. Force majeure clause is going to make both parties whole without the consequences of the breach of contract. You can reschedule, you can repay, you can redo if you want to, but in the event neither party wants to move forward, neither party will be penalized. Parties will be made whole as if the contract never happened. This was critical during the pandemic. A lot of parties did not have this in place, and it cost a lot of contracts. A lot of businesses lost work over the pandemic. Mine was booming because people needed to negotiate contracts that did not have force majeure clauses in them. Wedding venues in particular, they were stuck and they didn't know how to move forward because they didn't have force majeure clauses. So very critical to have it, guys. Next, let's hop into intellectual property. A trademark, once we have all of these things in place, right? We have a contract that is, someone is creating a logo for us. They're doing our branding. We got to protect this intellectual property. These are actual assets that add to the valuation of our business, right? So a trademark is a registered mark that acknowledges and protects the unique brand mark that you have registered. This can be a logo, a hashtag, brand color, catchphrase, a business name, product or service name, and the process that we are working on for trademarking this is the process of how you file it, right? The most important phase by far is researching. There's no point in filing an application that's not available. You need to research in two places, in the actual trademark database, as well as in the market, because once you protect the mark, you have to enforce it. And if it's saturated in the market, it's going to be very expensive and cumbersome to enforce it to the point where it might not be worth it. And you shouldn't move forward with the application, honestly. So it's very important to know those two factors. Secondly, you want to prepare and file the application. This can get a little tricky. I think it's straightforward. I do trademark applications weekly. However, when you go in and you're like, what's a specimen? What's a class? The language that they use can be a little confusing. And so being clear on what the information is and how to properly fill out an application can prevent further delays down the line. Now, the trademark application is a little timely, guys. Right now, it is taking up to a year to get a response, but you are protected from the day you filed the application, guaranteed that it is approved. If it's denied, the protection doesn't exist anymore. They couldn't approve it. But if it is approved, it is backdated to the date of that application. So very good to know. From time to time, trademark examining attorneys are going to have questions. They're going to need more information. So after you file that application, they're going to send you a response. Usually they send about 3 to 4 before it's a final action. And if you don't give them what they're looking for, they're not going to approve your mark. The responses are very important. This is a federal process. This is a federal agency, and it basically is like going to court. They have time restrictions on when you have to reply. And it is very important that if you are not complying with those, they will deny your mark. And you got to start all over and pay the application fee all over again. They are not refunding fees, you guys. Lastly, if it's on the final mark, they give you an option to reserve an appeal. You have to pay a fee for that. But if you think your mark should be approved and the examining attorney, for whatever reason, does not understand your reasoning, you can challenge it by taking it to appeal and having the board actually reveal and understand or consider your trademark for approval. This entire process, well, no matter what step, once you make the filing, your mark is protected through this. So keep all of that in mind. This is going to be important for navigating the process here. And then lastly, I told you guys I was going to leave you guys for questions. We're going to have about 10 minutes here. But lastly is the copyright. And I always like to highlight this because every single business has a copyright. And this is probably the most underutilized intellectual property that is out there. If you have a website, you have copyright. If you have systems and processes within your business that you are creating, which we all do because we're running businesses, you have copyright. And this is an underutilized area because once you protect your trademark, once you protect your copyright, this is intellectual property that not only adds valuation and assets to your business, but now you can turn around and utilize your trademark and your copyright, and you can create licensing deals. You can create white labeling contracts, right? You can now franchise out your business. It's honestly, the potential is unlimited depending on what it's going to be best for your business model. But a lot of us have copyright within our business. If you are creating freebies, right? Lead magnets, which most of us are for our business, how we get clients, you have a copyright. And there's another business out there that may be infringing on your copyrights or stealing your ideas. And a lot of times we'll get upset. And I challenge my clients. I look at it and say, well, hey, maybe we can make this work in our favor, right? It's already protected. Let's not send them a cease and desist. Let's send them a proposal to actually maybe buy it out, and you can get royalties off of what you've already created, which is already in place and working for your business. Now you can make and create an additional stream of income by granting it out to other business owners. And you can regulate how you do that. This is business to business. This is what people are doing with government contracting. They're taking their business model, what they're doing and creating, and they're telling the government, I can do this on a grand scale for you. They're partnering with subcontractors, they're lending it out to them. And so it's really an advantageous business model if you haven't already considered it. Copyrights apply to paintings, music, manuscripts, art designs, movie scripts, copy, website copy is mentioned, curriculum, lead magnets, planners, anything that you create for your business almost. It's a limitless list almost in a sense. But it's a very unique opportunity for business owners to work together. So with that being said, I am done with my presentation. Well, let's hop right back into questions. I had a few in there already, so I'm going to go ahead and answer these. One was, is it always recommended to have an agreement with a 1099? Absolutely. It protects your business and it protects your relationship. Unfortunately, they work for themselves. So a lot of times I see agreements protect when independent contractors don't show up, which happens from time to time. It's unfortunate, or they don't perform to your standards. The difference between an IC and an employee is the amount of control you have over them. You cannot control a 1099 and dictate, you have to be at work at this time, you have to do this. Depending on your industry though, they are representing your brand. You can have expectations of work, how they deliver and how they perform. And your IC agreement is where you really get clear on that. And you can show you didn't meet the requirements. And so you didn't fulfill the contract, you actually breached it. So I absolutely recommend having that IC agreement in place. Is it confidentiality and non-compete and understood when interacting with representatives of the government agency? That's an amazing question. The Arizona Minority Business Development Center actually hosted a webinar. It was phenomenal. I don't know if you guys have that on recording where they can get it, but it was done by Sam. What's her last name? Gabriel Groves. Thank you, Alika. Gabriel Groves, she hosted a phenomenal, her nickname is Sam, by the way. I didn't get her name wrong, but Gabriel Groves, she hosted a phenomenal 4-week series over government contracting, and she went through everything. And this question was actually asked: how do we protect our trade secrets and our policies and privacy when we are submitting a proposal? And you can actually submit a letter and put it at the bottom of each of your pages and let them know that this is proprietary information and you would like them not to disclose it. And so it's not necessarily an agreement that you're having them sign. It's a letter that you're submitting to them with your proposal, asking them to do that. And per their records, if you are the winning contractor, they will redact that information. They will further send it to you to redact more information. But this is a great question because most people think with the government, you can't protect yourself. You absolutely can. And it is a way that you go about doing that as well. So great question. Awesome. I'm glad you think it's great. So how do you feel about the use of standard industry contracts from professional organizations? I am a consulting engineer and purchased the engineer's joint contract documents, committee standard forms, and contracts. Should those be reviewed additionally by your legal counsel? I absolutely think that they should. In fact, I just came back from a government contracting conference in Virginia this weekend. I was in person. They had government agencies there. It was phenomenal. and this question got brought up. An example specifically is that you have field experts, which would be your industry that is giving you the contracts, right? But they are not legal experts majority of the time. And so you need both. I don't understand the ins and out of the consulting industry for engineers, right? I need someone from the inside to take me through the processes, the procedures, what is going to be required to fulfill this work. And once they give me that insight, I can then go on and answer the legal side that would accompany the goals that they have with that project, right? Maybe there's a policy or procedure that's not going to be legally enforceable if it's not attached the appropriate way to a law, right? And so I always recommend, it's great to get these contract templates and things like that, but two things need to happen. It needs to be reviewed by an attorney, but additionally, you need to understand how this contract impacts your business because you are the business owner. You are the person enforcing it day to day. And so that's going to be an important component that I think both play a role in the operation of your business. But great question as well. Can I touch on IP clauses and copyright? I believe I just did that. I think this was posed prior to me talking about the intellectual property. It says you hire an IC for content creation. When you hire someone, they usually are creating for your company and you're going to own, just to be clear, but you should detail that out. So for clarity, so there's no confusion within your agreement. You file a copyright at copyright.gov. It's many types of copyrights though, so you want to make sure you're filing the right application. They do have collections where you can file in bulk. If you have photos and videos, can you copyright it in bulk? But they have specific requirements for that, right? So it sounds like you maybe potentially have a course or a curriculum that you're offering. It's going to be, you're probably going to have a combination of different types of applications, honestly, for how you are submitting it. So you want to go through, make sure you have the right type of application, and then you submit it from there. What is the process for creating a copyright on the contents of a website? Great question. So just so you all know, copyright is a little different because you have an inherent right from the moment of creation. However, if someone, and it happens, you guys, I've consulted many people where the people will come and take your entire website and they will, awesome. Yes, I can unshare so it's easy for you guys to see me. You can go onto the copyright website and you can create, wait, let me pull that question back up, make sure I'm still answering the right question. So when you go on the website, everything you created, it inherently has a copyright right. However, you don't want to go through the cumbersome of having to prove if it was yours first or if it was theirs first. So registering the copyright gives you that timestamp of approval from them, and it is the first right of record. So the first person to do it is the first person who received the protection from it. You then become the person who owns that copyright versus someone who did not protect it and they just stole it from you, right? So you have a claim just from creating it, but taking it a step further and registering it. And copyright registration prices start at $45, you guys. So it is the least cumbersome and the easiest of the intellectual property to protect. I highly recommend that you are taking that and implementing it into your business practice, because once again, if someone ever said, hey, I love your business model, I love what you do, I want to buy your business, it becomes more valuable when you say, great, you're going to get all of these registrations with the copyright agency, the trademark agency. I've protected this business, and now you can franchise it. You can white label it out. You can do licensing agreements. It makes your business more valuable, you guys. So it's very important to make sure that you are utilizing these protections as well. I do want to pause. If we have reached our hour mark, I absolutely don't mind staying on and answering a few more questions if you guys would like, but I do want to turn it over to our event hosts to make sure that's okay with them. And if they have anything they want to say in the interim.